Hello, my name is David Nash. I'm legal counsel for the New Jersey Principals and Supervisors Association and coordinator for the Legal One program. I'm here today to talk with you about a major change in New Jersey law, the signing of the Anti-Bullying Bill of Rights. The law was signed by Governor Christie on January 6th of this year, and the law includes some dramatic changes to how school districts must address bullying in schools. The new law goes into effect September 2011. And the purpose of this video is to review some of the major changes in the law and provide you with some basic information about training opportunities that are available for school leaders and school districts to address the new provisions in the law. I want to first begin by stressing that many aspects of the law on bullying really have not changed. New Jersey signed an anti-bullying bill into effect in 2002. And I'm going to review with you those provisions in the 2002 law that are still effective and will not change in September. There are some new provisions that we're going to be reviewing, including some revision to the definition of bullying. The new law clarifies issues related to how we address conduct away from school grounds. I'll review with you some of the unique provisions in the new law, including a provision dealing with school safety teams. There's a new provision requiring an anti-bullying specialist to be in place in every school. There's a new requirement for all schools to have an anti-bullying coordinator. And there really are some significant changes in how school districts have to conduct investigations and report incidents of bullying that we'll be reviewing as part of this video. The new state requirements on reporting incidents of bullying have changed, and there are going to be specific new provisions that school districts must comply with for how they report incidents of bullying to the state of New Jersey. There's also a new grading procedure, and schools and districts are going to be graded by the state of New Jersey on how effectively they address incidents of bullying in our schools. There are new training requirements that all school districts must comply with, and the new law clarifies instances when school employees may be subjected to disciplinary action. So we're going to review all of those issues as part of this video. First, let me begin with a new definition. The new definition of harassment, intimidation, or bullying has several major components. The first is the type of action that we're looking at. The law is very broad, and it has been since 2002. It could include any gesture, or any written, verbal, or physical act, or even any electronic communication under revisions to the law that now includes cyberbullying. The law addresses the motivation of the action. It could include any actual or perceived characteristic that a student may have. There are some examples that are spelled out in the law, such as race, color, religion, ancestry, national origin, gender, sexual orientation, gender identity and expression, disability. But the law also says that the motivating factor could be any other distinguishing characteristic. So it's a very broad definition. And again, that's been true since 2002. The law also addresses where the alleged incidents of bullying may have occurred. Obviously, it deals with incidents that occur on school property, at school-sponsored functions, on a school bus. But the law also makes clear that in many cases, you must address conduct that occurs off of school grounds. And we'll address that in more detail later on. The new definition talks about the level of action that rises to the level of bullying. Not all issues involving student misconduct constitute bullying. It requires in all cases that we demonstrate, in order for an incident to be considered bullying, that the incident led to substantial disruption or interference with the orderly operation of the school, or a substantial disruption or interference with the rights of students, and that it meets one of the following additional conditions. For example, we have to determine whether or not the behavior had the effect of insulting or demeaning students or a group of students, or did the behavior create a hostile educational environment for students. Now, it would create a hostile education environment by interfering with students' education or severely or pervasively causing physical or emotional harm to a student. The revised language is similar in the legal standard that's being applied to school district. So the new definition clarifies the need for a threshold showing of substantial disruption with the orderly operation of the school. But that's been true for many years under case law. The new definition clarifies that bullying may be from a single incident or a series of incidents, But again, that's been true and has been made clear in case law for a number of years. The new law also clarifies that bullying could be something that results in either emotional or physical harm. It doesn't have to be physical harm, certainly it could be emotional. But again, that's been true for many years based on case law. The new law clarifies that the incidents could occur off school grounds, as well as incidents occurring on school grounds. That's something that we have seen for many years in case law as well. The new law does create a new term, hostile educational environment. But again, the law still requires a threshold showing that there has been some substantial disruption to the school environment. The new law clarifies that school districts have a duty to address bullying that occurs off school grounds if the behavior meets the legal definition of bullying that we just reviewed, including causing a substantial disruption, and that the behavior is demeaning to a student or group of students and or creates a hostile educational environment. As far as conduct away from school grounds, in New Jersey there has been an obligation for school districts to address conduct away from school grounds that disrupts the environment for many years. There's a decision in New Jersey going back to 1971, a case called RR versus Shore Regional, that made clear that school districts have a legal obligation and duty in many cases to address conduct away from school grounds. The new requirement has been in New Jersey's administrative code since 2005, saying that in certain situations we must address conduct away from school grounds. There has been some misunderstanding of the new requirement. There are some who believe that it only deals with what we call portal to portal. And by portal to portal, we mean when a student is either going to school or from school back to home. That is part of the duty of a school district to address conduct that happens portal to portal, either going to school or from school, but the obligation is much broader than that. And if we have conduct that occurs on the weekends away from school and it causes a substantial disruption to the school environment, there's still a requirement for you to address that behavior. Some examples could include students fighting at a park, where perhaps a student who is beaten up by another student is now distracted and fearful in school, and this causes a disruption to the school environment for that student. The school district now has a duty to address that behavior. Another example, and this is one that unfortunately has become common across the nation, is the issue of cyberbullying, where much, if not all, of the behavior is occurring off of school grounds, but it's causing a substantial disruption to the school environment for a student. And again, in that situation, there would be a requirement to address the issue. One major new change in the law is the requirement for every school to have an anti-bullying specialist. This is a new position that has not existed in New Jersey before. The new position is one that must be appointed by the principal. The principal is required to appoint someone to this position who either is a guidance counselor, a school psychologist, or the legislation talks about other similarly trained individuals. If none of those persons is available in a particular school, the principal is allowed to appoint someone else from the staff to serve as the anti-bullying specialist. The duties of the position are very broad. This anti-bullying specialist is required to lead investigations of bullying incidents. It's the primary official responsible for preventing, identifying, and addressing incidents of bullying in the schools. And this is the person who's going to chair the newly created school safety committee that every school district and every school must have. The anti-bullying specialist will chair that committee. The committee is required to include either the principal or the principal's designee, a teacher, a parent, and other members as determined by the principal. The duties are very specific. The school safety team is required to receive complaints of alleged bullying from the principal, to receive copies of all investigation reports that are completed on alleged bullying incidents, to review and strengthen school policies and procedures related to bullying, to review and identify patterns of behavior regarding bullying in school, to participate in training programs related to bullying, to collaborate with the newly created district-wide anti-bullying coordinator as far as the collection of data and development of policies. Parents are an important part of this committee, but they are excluded from any steps that the committee takes to investigate specific incidents of bullying. So the parent cannot be part of receiving information about specific incidents or reviewing patterns of behavior related to specific incidents. And the reason for that is clear: to make sure that we're protecting the confidentiality rights of students. Parents will be involved in the other activities of the school safety committee. Another new position that we mentioned is the anti-bullying coordinator. That's a position that's a district-wide position appointed by the superintendent of schools. The duties include coordinating and strengthening district policies, collaborating with the anti-bullying specialist in every school, providing data to the Department of Education, and meeting at least 2 times each year with the anti-bullying specialist from all the schools. The new law includes very specific, very detailed investigation procedures. It's critical that school districts become familiar with the timelines in these procedures and what must be done at every step of the process. This is an area where a school district could face significant liability if they don't meet these new investigation requirements. The verbal report of a bullying incident under the new requirements must be made to the principal, and that report has to be made on the same day the incident occurs. So if there's any staff member, any volunteer in that school who is receiving information about bullying, they must immediately, on that same day, report it to the principal. There then has to be a follow-up written report. So whoever did the verbal report must complete this written report within 2 days. The principal then has to investigate an investigation. And actually the law is not clear on whether the investigation must begin within 1 day of the verbal report or the written report. So what we're recommending is that the principal immediately initiate that investigation, certainly within 1 day of receiving the verbal report. The investigation must be conducted by the anti-bullying specialist. Now, the new law does recognize that these are, in some cases, very complex investigations requiring interviews of many students, potentially many staff members and other witnesses. So the principal is permitted to appoint other individuals to assist the anti-bullying specialist with the investigation. The investigation must be completed as soon as possible, but no later than 10 school days from the date of the written report. The new law does recognize that there may be a need to amend that report even after it's been completed. So you do have the right to amend the report at a later date. The report must be given to the superintendent within 2 school days of completing the investigation. The superintendent must then decide what actions to take. The range of options include intervention services that would be recommended to deal with a bullying incident, perhaps a need for training programs in the school or district. The superintendent must make a decision about imposing discipline on any alleged bully in the incident that occurred. And the superintendent has the option to order counseling for students involved, both the potential bully and victim. The report of the investigation must be presented to the Board of Education at the next board meeting following completion of the investigation. Parents of both the alleged victim and the alleged bully do have due process rights that are spelled out in the legislation. Parents of all parties have rights to receive information regarding the investigation that took place. The information must be provided within 5 school days after results of the investigation are reported to the board. The parent of any of the parties may request a hearing after receiving the report, and that hearing must be provided within 10 days of the request. The board then is obligated to issue a decision in writing at the next board meeting following receipt of the report. The parents of parties involved in the action may appeal any decision of the board to the Commissioner of Education, and they have to do that within 90 days. The parents of the alleged victim also have additional rights. They have the right, if they believe that the civil rights of their child were violated, to file a complaint with the New Jersey Division on Civil Rights. That would have to be done within 180 days of the alleged incidents. Parents also have a right to file in Superior Court or in Federal District Court if they believe the bullying that occurred is based on a protected characteristic under state or federal law. Regarding bullying incidents, the law makes clear that employees may be subjected to discipline if they don't properly address and respond to incidents of bullying. School administrators who fail to initiate or conduct an investigation, or who should have known of an incident and failed to take action, may be subjected to disciplinary action. A key issue here is when a school administrator should have known that bullying was occurring in the school. This is a fact-sensitive issue that would require significant investigation of when incidents were occurring, what witnesses there were, what information was provided or should have been provided to the school administrator. You do need to have, as a school district, clear internal reporting procedures so that you can show that you have done all you can as a district to make sure incidents are being properly reported. And you also need to make sure that you're providing the required training so that school employees know how to properly report incidents of bullying. There are a range of potential disciplinary actions that an employee could be subjected to if they fail to take appropriate action. A school administrator who either failed to initiate an investigation or who should have known of an incident and failed to take action could receive a disciplinary memo, could receive an increment withholding, could have tenure charges filed, depending on the facts and circumstances in the individual case. The point in the legislation is that this is a very serious issue, and you need to make sure you take appropriate action to avoid any potential disciplinary action. The law also makes clear that board members may not engage in any sort of reprisals against any witnesses or victims or anybody involved in reporting a bullying incident, and that board members could be subjected to a disciplinary action too if they act inappropriately. The new law includes some major new reporting requirements that we have to comply with. The New Jersey School Report Card will now include specific information on bullying and the number of incidents that occurred in the district and in particular schools. 2 times each year, the school district now must report to the board on acts of violence, vandalism, and bullying that occurred in the school. These reports to the board must happen once between September 1st and January 1st, and once between January 1st and June 30th. This data must also be reported to the Department of Education. And in reporting the data to the department, it needs to be very specific. It needs to include a breakdown of the reasons for each of the bullying incidents that occurred in the school. And as we mentioned earlier, those reasons could be very broad. Could be that the bullying is related to race, ethnicity, sexual orientation, or some other actual or perceived characteristic of a student. All of that information needs to be included. The Department of Education is now charged with taking that information, all of the data provided by the district, and assessing how effectively schools and districts are addressing bullying in the schools. And every school and every district is now going to receive a grade from the Department of Education on how well they addressed incidents of bullying. The grade is based on your efforts and your effectiveness in implementing new state law and board policy. The Commissioner is going to develop guidelines for how school districts will be graded. The grades must be posted on the school's website, and there must be information on the district website about how to access the grades as well. The Commissioner of Education is going to put together guidance documents for school districts to assist you in implementing the new law, and will also put together some formal protocols for executive county superintendents. Because the new law includes a role for the executive county superintendent in investigating any complaints that a school district failed to properly deal with a bullying incident in a school. Let me stress that this presentation is intended to provide a basic overview of the new law. The new law is very detailed and very specific. It's beyond the scope of this presentation to address the full legal requirements, including the many cases that have come down in New Jersey and at the federal level dealing with bullying. The case law is something that we would address much more fully in broader training. This overview is not intended to deal with the practical application of the law in real-world settings. We do provide training that allows you to go through exercises where you specifically apply the law to specific incidents, and we address how you would do that in a way that effectively complies with the law. It doesn't go through how to properly conduct an investigation. Again, that's something that we do work with school districts on through more detailed training, how to properly do these investigations. And as we mentioned earlier, we do have school counselors now, in many cases, who will be appointed as the Anti-Bullying Specialist, who will be doing these investigations. So there is a real need for training on how to do that properly. The new law does require that districts provide annual training for all staff on their Code of Student Conduct. This would include training on the bullying provisions in your Code of Conduct. The new law requires that as part of the required suicide prevention training that school employees receive, that bullying be included in that training as well. School leaders must also, as part of the 12 hours of training that they're required to complete, have training on bullying and harassment. Legal One does provide that training, the 12 hours of training for school leaders, and within that program we do address the bullying and harassment issue. There's also a new requirement for all school administrator preparation programs to include training for new and incoming administrators on the issue of bullying. FEA's training programs fully comply with these new state requirements. We have designed programs that address really two major issues that are both critical. A Legal One, which is a collaboration of the Foundation for Educational Administration, Rutgers Law School, and the Monmouth Ocean Educational Services Commission, provides training dealing with legal compliance and how we address all of the specific legal issues related to bullying and harassment. That training is available both in half-day and full-day programs. FEA also provides a bullying prevention program that deals with best practices. This is based on the nationally researched and renowned Ulvaeus model, and it's something that has worked extremely well in school districts across the nation. On this website, we have information on specific training dates that you may wish to access training both on Legal One and on FEA's bullying prevention program. For more information, we encourage you to go to the FEA website, to the Legal One website, to the NJPSA website, or to the website of the New Jersey Department of Education. Information on those websites is provided for you on this site. As you can see, New Jersey has put into place a comprehensive new scheme for how we address bullying and harassment in our schools. This is a tremendous change in the law for New Jersey school districts. It's something that in many ways has been inspired by tragic events both in New Jersey and across the nation, where we have had students who have committed suicide and had other horrific consequences imposed to them because of bullying and harassment. The new law is intended to ensure that we do everything possible to make sure those incidents don't occur in the future. We urge you to take the time to review this video with your staff, to review other materials that we provide on our websites, and to take the time to ensure that all of your staff are properly trained to address this critical issue. Thank you.